Hello and welcome to the Northeast Law Review. My name is Nathan Cooper. This is Rebecca Bestley, and this evening we are joined by Dr Josh Jowitt, who is a lecturer of law at Newcastle University and currently a visiting scholar at the MPIL in Heidelberg. Hello to you, Josh. Thank you so much for being able to join us this evening.
That's all right. Thanks for fitting me in. I know there was a weird time change, wasn't there? So I appreciate you working around me.
Absolutely. So we're just going to dive straight in. We've got a paper that you've just released in this current calendar year, entitled "Legal Rights for Animals: Aspiration or Logical Necessity." But before we get into that, we just want to ask you a few questions about your route to law. So you studied law at university, presumably?
Yeah, that's right. Yeah.
And how did you make the step from studying law at university to going to work in legal academia?
It's a weird one, to be honest, Nathan. If you'd have told me at any time during my degree I'd have ended up being a law lecturer, I think I'd have laughed at you at least, if not got a stronger reaction. Because my original degree was a joint degree where you were going to study 2 years of English law and then 2 years in French law in Paris. So I'd always wanted to work in some kind of multinational institution, whether it was the EU or the Council of Europe or something like that, to make use of that English and French law joint degree. But then that was right in the middle of the credit crunch in 08 and 09. So that part of the course kind of got pulled a little bit. So I ended up just staying in the UK and doing my third year of the law degree in Cambridge instead. And I was just sick of it because it wasn't what I'd signed up to. It wasn't what I thought I was interested in. I didn't want to do law anymore. Like, I was just done with it. So I actually worked for my old uni for 2 years after graduating, doing some widening participation, some access and outreach work. Because it's something I say in a lot of things I do. I was the first in my family to do A-levels, never mind even think about going off to uni. So I know how difficult it is sometimes to take that jump and try and figure out, well, is law actually a subject for me? Is it something I want to do? And I was lucky to have somebody come from Sheffield University to my old college to do that talk. And I thought, well, I'd quite want to do that as well. So I did that for 2 years. And in the course of doing that job, a lot of teachers asked me to do specifically law-related talks, because I was just doing general, hey, guys, think about uni. And they were like, well, you did a law degree. Why aren't you talking about law? And so I started thinking about what about the law degree actually interested me. Because I thought there's no point in me going into a school and talking about something even I don't care about. I've got to at least pretend to be interested. And it was, for me, the kind of mix between law and justice. I found that really interesting, how a lot of people have completely opposite polar reactions to whether or not a certain legal case, a legal decision or a policy paper is just or unjust. So I found that really interesting. And I realized going around these schools across West Yorkshire, you know what, actually, I think this is something I want to do a little bit more work on. So I applied to do a master's after 2 years. I did that at the University of Warwick. Realised I still enjoyed it, and then I was lucky enough to get a funded PhD up in Durham, and I spent 4 years doing a PhD in Durham, looking specifically at morality and how morality fits in with the idea of a legal obligation. Why is it that the law is something we should follow? Is it connected to ethics and morality, or is it something completely separate? So sorry if anybody's already having flashbacks to Lim in first year, but that's kind of what I'm actually really interested in. And then so I started lecturing at Newcastle in 2016. It was a strange career direction. I didn't expect myself to take it back in 2009 when I graduated, but yeah, here I am, loving every minute.
Good you're still it's good that you're still enjoying it.
Yeah.
So you've got a paper that's come out about the rights for animals. Mm-hmm. Could you please tell us why you were interested in this topic?
It's to wind my mum up. Genuinely, that's how I got into it. I don't know if you can remember a few years ago, there was a case about monkey selfies. I don't know if either of you spotted that when it was on the news. We're talking a good 4 or 5 years ago now. And there was it's like Google monkey selfie case, and you'll see what I mean. And It was all about this macaque in Indonesia had been walking through this. That's how it walks apparently. It's walking through this rainforest sanctuary, and there was a photographer who'd left a camera trap in the middle of this sanctuary, and this macaque saw this camera trap, dismantled the entire thing, and then just took a load of selfies of itself. Now, obviously, it didn't know it was taking selfies. It could just see like, oh, I push the button and the camera does something. But the pictures are brilliant. Like, they're absolutely fantastic. So this photographer found his camera, saw it had been trashed and thought, oh, God, this is going to be awful. Looked on the memory card and was like, this is immense. This is incredible. And he published the Big Book of Monkey Selfies. And then an animal rights group from the US got involved and said, well, hang on. You didn't take the photographs. The monkey took the pic. It's not a monkey, it's an ape. People will shout at me if I get that wrong. But the ape took the photos. So actually, you don't own the copyright, Mr. Photographer Man. It's the ape that owns the copyright to those particular images. And I was just talking to my mum about this on the news one. I was back home for Christmas, and I was talking to my mum about it, and she just looked at me and said, "Don't be bloody daft, Josh. It's a monkey." So I told her it's not a monkey, it's an ape, and then that ruined Christmas, and she didn't talk to me for 3 days. But then there's that thing I was talking about earlier. 2 different people had a completely and utterly different reaction to that. I found this really interesting that somebody thought, well, hang on, you know what? Why shouldn't the monkey, the ape, God, be the copyright owner? And my mum's reaction was, it's a bloody monkey. Like, don't be stupid. So yeah. I decided to do a little bit more work on that and whether I thought apes could hold legal rights, just to wind my mum up. And then 3 years later, I'm still doing it.
Well, it's snowballed then. So what are the legal rights then that animals currently possess?
So it's a funny one, Nathan. You ask 10 different people working in this field what legal rights animals have got, and I can guarantee you'll get 10 different answers. Because not only does it vary a lot from country to country, every single jurisdiction has its own distinct field of law on that question. It depends on what philosophical outlook you're coming from as well. So if you're talking about what protection, I'm going to interpret rights there for a second as protection, if you don't mind.
Yeah, it's fine.
What protections do animals have here in the UK? Then it is governed by the Animal Welfare Act. And basically what the Animal Welfare Act does is lay down certain minimum thresholds, certain standards that animals have to be kept in, prevents basic cruelty and abuse to animals in that level. But there's interesting exceptions where the suffering cannot be unreasonable. You can only get prosecuted if you cause an animal unreasonable or unnecessary suffering. Now that means there must be necessary or reasonable suffering that it's okay for us to inflict on animals. And my take then is if you're allowed to inflict reasonable suffering or necessary suffering on an animal, then how can that animal even have any rights at all? I don't think it makes sense to say that, well, you've got rights, apart from when actually it's in a human's benefit to do something bad to you, in which case you don't really have rights anymore whatsoever. So it's a more difficult question than I think you realise, Nathan. It all comes down to, well, what is a right, and can animals have rights whilst they can still be owned as property?
In your paper, you talk about 2 broad ways in which legal rights for animals are construed. What are they? If you could tell us.
So there's 2 main positions at the minute, Becca. There's what we call the welfarist position and what we call the rights-based position. So the welfarist position, the clue's in the name, is concerned with animal welfare. And broadly speaking, that's kind of where we are now, is that most legislation that's out there will try and set minimum welfare standards for animals, so that if you cross that or if you don't give them adequate welfare, then you've committed some kind of offence. Now, what the welfare status doesn't do, and this is something that I criticise it for in that paper, is challenge the property status of animals. It says that animals have a certain standard of welfare, you can't abuse them, but they're still property. In the same way as, for example, you could imagine a law that says you're not allowed to desecrate a painting, or you're not allowed to graffiti a monument, right? You're still saying the monument's property, the painting's still property, you're just saying you can't do certain things to it. And that for me seems to be a problem from an animal rights perspective. If we think that animals should have rights, then we need to challenge that property paradigm and say, okay, well, animals aren't property anymore. And that's what the second of the two approaches is trying to do. The rights-based approach is really trying to challenge that property assumption and say that, okay, the only way we can have rights in any meaningful way for non-human animals is to get rid of their property status at all and say that, okay, they're now beings who have legal rights in their own stead. And for that, we need to start thinking about things like legal standing and also legal personhood.
So just tying in with what you were just saying then, Josh, about the rights-based approach, you've written in the very same paper that presupposing a legal positivist outlook you drew upon Lon Fuller, for example, presupposing that outlook of a positivist outlook of the system of law can limit the effectiveness of that approach towards animals. In what way does the positivist approach tie into that wider approach towards animal welfare?
No, again, so I like that question a lot, Nathan. I'm going to begin with a content warning again, if you don't mind. That this is limb heavy, so I'm really sorry for inflicting this on you. I think I said this in the lectures, Becca, because I taught you limb, didn't I?
Yeah.
Yeah, but you were the year above Nathan, so I didn't take you. Sorry, yeah. So I always make a point of trying not to tell you which of the interpretory approaches I actually have the most sympathy for, which one I'd subscribe to. So I introduce you to the realists, the formalists, the natural lawyers, the positivists, the critical legal studies, all the rest of it. This is the one time I'm going to let anybody record me as saying what I actually think without going away and reading something I've written. So confession alert, I am a rare breed. I am a very hardcore natural lawyer. There's not many of us left in the world, but I'm one of them. And I think that you can only make sense of law if you accept that there's some kind of connection with morality there, whether you're talking about justice or fairness or whatever. There needs to be some kind of moral reference point that the law can then run with and turn into legislation or turn into rights or case law or whatever, but none of it makes sense unless you accept there's a moral core. So I think it's a problem that the current approaches, both of them, don't take that into account at all, right? So the welfarist approach kind of just sees animals as property. Now, if we can find some kind of moral reason to say that animals are not property, that actually animals have moral worth, just like you or I, then the very fact that we're seeing them as purely property is a problem, right? Yeah. But the positive law, legal positivism, doesn't let us do that. It just says, well, the Westminster Parliament has passed the Animal Welfare Act, therefore that is the law, end of. Yeah. So I don't think that's a satisfactory state of affairs. That for me is not a legitimate, well, that for me is not a law at all. It's a statute, but it's not actually law. So that's a problem there because you've not got that moral basis underpinning the statute. So, for example, in the past, and I think I mentioned this in Lim as well, women were seen as property under English law, the doctrine of coverture, and Blackstone described that in quite heavy detail and said, well, a woman's property, she's not her own person, she doesn't have rights. As soon as she gets married to a husband, she's property. Now, we can all see that as just bonkers. That's mad. It's clearly utterly wrong. But that's what the positive law said. And that's where I think we need to come to nowadays, is say, well, if we think actually that animals are of moral worth, then we need to reassess that property standpoint. So that's the positivist problem with the welfare position. And my positivist problem, I suppose, with the rights-based position is that a lot of the current theorists and the animal advocates and lawyers working in the field are trying to get the legislatures on board. They're trying to persuade the courts to take an active step, or the legislator to take an active step to recognize that animals have legal rights, that they have, we have obligations to them that need to be reflected in law. Now, by presupposing actually that that's something that needs to be done, we're saying, well, animals don't have rights until the law says that they do. Yeah. And again, that for me is a problem, because the presupposing, again, if we're saying, well, the law should reflect that animals have rights, then we need to say, well, animals do have rights. They already have moral rights, and they're things that should be reflected in the law. And as a natural lawyer, I think something can only be law if it takes that moral consideration into account. So by kind of saying, oh, well, you know, maybe we can change the law to make sure that animals do have rights, we're ignoring the fact they already do.
Thank you. It's very interesting.
The rabbit hole I completely fell down. Again, never mind if you'd have told me I was going to be an academic lawyer. If you'd have told me I was going to be doing animal rights law 10 years ago, I'd have laughed at you as well. I genuinely started doing this to annoy my mum, and I love it.
So linking to that, actually, we have a question about the meat industry and how rights for animals, how would this change meat for consumption, for, well, human consumption?
Okay. So, well, I think the starting point we need to think from there, Becca, is why is it that animals have rights? Because again, we're kind of presupposing there that every animal that might be consumed has rights. Mm-hmm. So to do that, I think we need to have a think about why we think maybe we have rights, and then ask, well, does any animal that possesses that same quality, that same criterion as we do, if they have it, then they must also have rights. So there's a couple of different routes we could go down there. The most commonly accepted one is sentience. So any sentient animal that can feel pain or is aware of its own existence in some way is in possession of rights, because it's in their interests and it's in our interests that if we feel pain, we don't want to hurt ourselves. So we can presume other animals wouldn't want that to happen to them. So we're kind of undermining our own rights claim if we say, well, it's fine to kill a cow, but it's not okay to kill a human, for example. There's kind of a contradiction there. So on that outlook, we'd say that any single sentient animal, then, it would be immoral, and in my natural law framework, illegal to kill it for human consumption. Now, there are some nuances around that argument. So, for example, you've got people like Peter Singer, who's a famous Australian philosopher, who says, well, actually, we can legitimize meat consumption or dairy consumption if we can ensure that the animal doesn't suffer at all during the production process and during the kind of milking process. For example, if we're talking about cows, if it doesn't suffer at all, then actually it's fine as long as the slaughter is also completely suffering free. Which is a nice thought, but looking at the state of current agriculture, I don't think we're anywhere near there. Fun fact about me, my first job was actually at a cattle market, and I can tell you it's certainly not there in the husbandry industry in South Yorkshire, let me tell you. My own approach, though, is something a bit different. I think it's to do with agency. And I'm sure you're going to ask me later on what agency is, so I'm not going to bore you with that just now. I'm going to answer your actual question. So I would say the same, yeah. Animals shouldn't be killed for meat. They shouldn't be reared for cheese or eggs or milk or whatever, if they're an agent. So an agent is, for me, something that can choose what to do. It can have a plan. It can exhibit preferences between two different types of behavior. So pigs, I think, for example, here would be an obvious agent. I don't know if you've ever watched like videos of pigs solving puzzles or exhibiting certain like rational behavior. No, again, I'm just going to send you loads of YouTube links.
Yeah, I'll definitely watch that when it comes through.
Yeah, pigs are incredibly intelligent animals. They're definitely agents. They can choose what to do. They can solve puzzles, for God's sake. So I don't think we should be eating pigs at all. Take that to octopus as well. I think octopus, we can all remember Paul the psychic octopus from a few years ago. I'm not saying that octopus are psychic, but they're also definitely intelligent. They can open jars, they can kind of solve tricks, they can see themselves in a mirror and recognize themselves. So that for me is a sign of an agent. A squid, I'm not sure. I don't think a squid's an agent, because from all the stuff I've seen, I'm not professing to be an expert, but squids seem like idiots. So I've got no problem eating a squid, for example. But then there's the grey area in between, Becca. So it would have big implications for the animal husbandry industry, for meat, for dairy, for eggs, for all of those things, for fishing. But also be incredibly complicated, I think, trying to separate, okay, well, which animals do we think are not okay to eat and which ones are probably fine.
So sort of tying in with what you were saying at the start of that response, Josh, in terms of sentience, sort of loosely linking it, there are numerous thinkers out there, the blockbuster ones, Immanuel Kant, Thomas Aquinas, who claim that they think that animals were sort of given to humanity, as it were. I just wanted to know, and this is a very opinion-based question, where you sat on that and what your opinions on their views in that regard are.
There's a wonderful thing about being an academic, and you kind of see in a lot of people's writings, it's like being an internet troll. Like, you can just say what you want, and you can be really harsh and say stuff you'd never say to anybody, like to their actual face. I think they're wrong, Nathan. I think they're absolutely like barking up the wrong tree, to pardon the animal joke. But not only are they wrong, it doesn't even matter whether or not they're wrong, because that doesn't get away from my own preferred theory, which is Jowitt's theory, which is something I talk about a lot in this paper. It doesn't matter whether Aquinas is right and God gave animals to us to enjoy. If the animal's an agent, then we should respect them. It's the same with Kant. If Kant says, well, animals are kind of unable to have a rational mindset anymore, so they're not deserving of rights, we can see from modern day neuroscience that he's wrong. We need to remember that these historical thinkers were writing very much with a narrower understanding of science, of neuroethics, of sentience, of all these different ideas that they couldn't even begin to imagine existed, never mind understand them to the length that we do now. So I think they're very much limited by their time and place. And if we come at them with the knowledge that we do actually now possess, then we can plug those gaps and say, okay, well, maybe there's a little bit of truth here in Kant. Maybe he's right that all rational animals are deserving of rights. But the bit where Kant was wrong was when he said animals aren't rational. And we can see now that a lot of animals are rational. They do have the ability to make choices. So actually, on a 21st century understanding of Kant, Kant would probably say, yeah, animals have rights, crack on. Votes for pigs.
Well, I think I can put your mind at ease here and say that I don't think they'll be watching this video. So I think we can sleep well. We can sleep well tonight after that.
The amount of times I look over and Thomas Aquinas are just giving me evil. Again.
In your paper, you write about a Jowittian ethics.
Yep.
Can you please explain what this is and why this is desirable in regards to your research?
Yep. So that question then, Becca, brings me back to the agency point that we were talking about earlier. The problem with natural law and trying to come up with some kind of natural law framework is that you need to prove that the moral theory that you're working with is objectively true. And that there's no way of disagreeing with it, because we all know that people disagree about what is moral and what is immoral. That's just a fact. Natural law can't work on some kind of relativism like that. You need to say, is this action moral? And you need a clear answer, yes or no. And that's where I think Jowitt can really, really help settle what is right and what is wrong. Because Alan Jowitt, was a guy who was writing out of the US in kind of the 70s and 80s. And he was Jewish, and he fought in the American army in the Second World War. He went over to Europe and saw the horrors that the Germans perpetrated, particularly in the concentration camps, based on that religious criterion. And that hit a particular note with him, given that he was also Jewish and probably lost family members in the Holocaust. And for him, the problem then was that the Nazis had just been able to remove every single right from the Jewish people resident in Germany and in the occupied lands legally. They just passed a law that said Jews aren't allowed rights anymore. So he thought, well, this then has a big problem for ethics, because that means that ethics can't take into account any kind of subjective capacity whatsoever. We need to start from something that everybody's got, whether it's religion, whether it's your social background, whether it's your race, your ethnicity, your sex, your sexual identity, gender identity, whatever. None of that can factor in deciding what ethics is, because as soon as you let one of those things in, then that's what people disagree about. So he said, strip it all back, strip all of that stuff back, and what you're left with is this idea of agency. And I said it earlier, agency is basically the capacity to do a thing, but not just do a thing, to do a thing for a reason, okay? So for example, I'm thirsty at the minute, so I'm going to pick up this glass and I'm going to take a drink. My glasses are slipping down my nose, so I am going to push it back up with my finger, right? I am doing a thing because I think I've got a reason to do it. I'm trying to get to a certain end result, whether it's quenching my thirst or stopping my glasses from falling down my face. Okay, so that for Jowitt is agency. And he says everybody's got that. Everybody can do that. It doesn't matter whether you're, what country you're from. Again, all those criteria I mentioned earlier are irrelevant. You're an agent. That's the end of it. And what Jowitt tried to do is say, okay, well, given we've got this objective foundation now, can we build a moral theory up from that bare idea of agency? And he thought you could. And he basically came up with this idea called the principle of generic consistency. And he said that you kind of have to treat every single agent in a way that respects two fundamental rights that every single agent needs, right? And those rights he thought were a basic minimum level of freedom, so your ability to move around unhindered, and also a basic level of well-being, whether it's physical or mental health. And he said every agent should see those as rights, because you need those two things to just be an agent. It doesn't matter what you want to do, whether it's pick up a glass, push your glass up your nose, pick up an apple, throw the laptop out the window. It doesn't matter. You need freedom and you need well-being to do literally anything. It's impossible to be an agent unless you have freedom and well-being. So that's why he thought there were rights. And then his principle of generic consistency says, well, then we need to treat every single agent to respect those two rights that they have. So that's kind of the cornerstone of Jowitt and Jowittian ethics. Now, the reason
everything thereafter builds upwards. Sorry, Josh. Everything thereafter is sort of building upwards from that.
Yeah. So every single other right that we might think we've got needs to come from those rights of freedom and well-being. And like that might seem kind of really strange way of looking at it, but if you think about it, most rights do. Your right not to be tortured is basically a right to physical well-being. Your right not to be held in prison without due reason is a right to freedom. Your right to get married, your right to have a family life is your right to freedom. So I think if you look at modern rights documents, Jowitt was onto something. Every single, what we'd call a substantive right that you have, like the individual rights to whatever, can be whittled down to freedom and well-being.
Now, I was looking earlier. I noticed you were writing about this going back to what you were saying previously about the fact you've started writing off about this to get back at your mum, essentially, and now it's snowballed. You're actually writing about this in 2016 with a title which I must say is perhaps the best title of an article I've seen in academia. Monkey See, Monkey Sue, Jowitt's principle of generic consistency. Very much like that. Now, in the current paper at hand, the Legal Rights for Animals, in section 2, you actually spoke about capital trials and about how traditionally in Britain there was an exclusion of butchers, specifically butchers, from jury service. I just would like you to flesh that out a bit if you could. So why would butchers per se?
Come on, butchers flesh it out. Really?
Did you like that? I was worried that might slip under the radar.
We're going to have beef if you carry on.
Oh, God. It is. So what was the purpose in forming that? Was it that it was perceived that butchers, because of the nature of their work, might be less sort of morally repulsed at capital punishment? Is that the rationale in forming that exclusion?
I should say, Nathan, that's apocryphal. We don't have any evidence at all that butchers were excused from capital trials. It's just kind of hearsay, especially in France during the revolution. It was like, well, in Britain, they used to ban butchers from being part of capital trials. So we've got no contemporary records. It's all kind of rumours a couple of hundred years after the fact. But the rumours are quite hot on the reason for it, and it's exactly the reason you just said. That because butchers are kind of killing beings every single day, that they might be less squeamish about passing death sentences on individual people, on human beings. And that for me is really interesting, because let's say, for example, that is true. It's not just a rumor that the French were talking about, these silly British lawyers. If that is true, then for me at least, the only way that makes sense is if the legal system thought, well, you know what, animals must be at least of some moral worth in order to have that effect on butchers, to have that numbing effect on butchers. You didn't see stonemasons barred from partaking in criminal offences because they were hitting a rock with a hammer and chisel and chipping bits off. You didn't see lumberjacks barred from jury trials because they were chopping down living trees. You only saw butchers. So there must be something different about animals compared to trees or rocks or other objects that means you can draw the analogy there between animals and people, and how you treat the animal and how you treat the people. And that for me is quite interesting, because it shows this idea of animals having rights and animals having moral worth. Potentially is something that actually the law did recognize, albeit a long, long time ago, and albeit maybe not true. But if it's true, then for me, that's something that's really interesting, that we've actually moved away from that in the last few hundred years, and it's only now that we're coming back to it.
I'm going to quote your paper now and ask you a question afterwards. So you say in your paper, welfarism explicitly accepts the position that rights of animals are secondary and can always be overridden if to do so is of an instrumental benefit to human beings. Right. So what is the alternative and more desirable position to this?
So again, we're going back to the starting theory, I think, here, Becca. So if Jowitt's right, and it's a big if Jowitt's right, then he says we should treat all agents as if they have rights to freedom and well-being. Now, the interesting thing there is Jowitt's not saying we should treat all human agents as if they've got freedom and well-being. He's saying agents. So any being whatsoever that possesses agency, that is an agent, that is capable of doing a certain thing because it has a reason to do it, has the same rights as you or I. Right? That's the starting point then for the Jowittian theory. Now, that means the starting point, I think, should be completely the opposite to the welfarist position that I've described. We should not at all allow any instrumental use of animals if that animal is an agent and the use would cause some kind of suffering. So again, to bring it back to pigs, I keep saying pigs because for me, they're the obvious animals that are most likely to qualify as an agent. It would mean that pig husbandry would go out the window tomorrow. Now, this is actually something I took a step to, and I've changed my diet now to cut out all pig products. When I first had this revelation about 2 years ago, I was like, well, I love bacon as much as the next man. Right? My Christmas tradition in my family is my mum wakes up at 7 o'clock in the morning, screams he's been, and then there's a bacon sandwich in front of you. Right? It's just something that's always been there. But I was like, you know what, ethically, I can't do this anymore. So that's the kind of change I think that we need to start seeing in the law. And it's something that welfarism just can't allow for, because welfarism says you can do this if humans can benefit from it. You only need to ban unnecessary suffering, necessary suffering is fine. From a Gowerthian point of view, that just doesn't make sense.
The final question on this paper, Josh, you may or may not be happy to hear, is the big blockbuster one. I'm actually going to ask you the question which you have posed rhetorically yourself in the title. So is establishing legal rights for animals something we should be aspiring towards, or is it a required logical necessity?
Okay. I was worried that you'd found some question that was kind of hidden on like page 27 in a footnote then, Nathan. I was like, oh God, what's he found? I can answer that one quite clearly. And I'm going to say it's a controversial answer, and it's very much inspired by my own natural law starting point. And that is that I think animals do have legal rights. I think every single agent, whether it's animal, whether it's human, whatever, has legal rights. And if a legal system doesn't recognize the fact that they have legal rights, then the legal system is wrong. It's wrong to do that. In the same way as a legal system was wrong to see women who were married as legal persons 250 years ago, or as in the same way that in 1991, there was still the marital rape exemption in English law. Lord Keith of the King Kell said in R&R, this was a legal fiction. The law was wrong to allow this particular exemption to the horrific crime of rape. I think the same is true of animal rights. I think in hopefully very soon we'll reach a point where we have a similar judgment, but aimed at non-human agents, and we can say, look, these animals are clearly of moral worth. They've always had legal rights, but the law was wrong when it said that they could not be actually enforced. So I do think they have legal rights already, and that the law is wrong to pretend that they don't.
Thank you.
Right.
So you have a proposal for future research, normative structures of legal personhood.
Yep.
How is this paper intended to differ from the current paper you've got? And are there any aspects of the debate which you wish to advance any further?
Yeah, so it's kind of the benefit of hindsight. I don't know if you guys think the same thing when you hand in an essay and then like as soon as you hand it in, you think, oh God, I forgot to say that. Or like, oh, actually that wasn't as clear as I'd have wanted it to be. It still happens to us. And that's the same thing that I felt when this paper was published. As soon as this paper was published, I reread it and I was like, you know what, that middle bit, it's a bit dense. That needs unpacking a lot more for this to make more sense. So the paper that I'm going to be working on, well, I am currently working on it. I'm going to hopefully be writing that up in the next couple of months, is going to focus in on the middle bit of the paper you guys have read, which is looking at the concept of legal personhood. Now, a lot of legal systems would say that in order to have rights legally enforced, you need to be a legal person, right? You need to be recognized as a person under law that has interests that you can then go to the court and say, hey, lads, come on, give me my rights. And I find it strange that a lot of legal systems don't think this is something that animals can be. I think I touch on it a bit in the paper you guys have read, but worldwide, rivers have been granted legal personhood, corporations have been granted legal personhood, buildings have been granted legal personhood. And it seems strange to me that we're okay saying that a company can be a legal person and bear rights, but the idea of a non-human animal, if it's a Gowerthian agent, not being able to be a legal person, why not? And that's the unpacking that I really want to do in the next article. So I'm kind of saying, I suppose, that legal personhood is something that we've not really thought through properly. We've got this assumption that legal personhood is something that a legal system can just give to things if it thinks that it's worthy, right? So yes, this temple needs protecting, so it's a legal person. This ecosystem is valuable, so the river's a person. We're coming at it from the wrong way around there. I think we need to think more about what is legal personhood as a concept. What actually is the structure, the normative structure of legal personhood, and where does ethics and morality come into that idea? And then once we've thought about that a little bit more, then we can say, okay, well, on that understanding, now we know what legal personhood actually is. Should animals be legal persons? And you might think that's quite a strange, I don't know, focus to be going on, but it's actually, what day is it today? It's the 18th of November today. Tomorrow, 19th of November, the judgment might be out by the time this is published. There's actually a case being heard in the Supreme Court of the state of New York about whether an elephant called Happy should be granted legal personhood or not. So this is something that is actually a very pressing legal issue in several countries around the world. And yeah, I think if we think more about the idea of what legal personhood is, then we can see that Happy the elephant is a legal person, and that the law should recognize that.
Amazing. Thank you so much.
All right.
That's all the questions that we had for you. Is there anything else that you'd want to say, or are you happy to?
Just want to apologise to my mum for still running with this. I think she's going to be like a 2-minute joke or something. But yeah, 4 years later, here I am still doing it. So sorry, Mum.
Well, thank you so much, Josh. It's been so great to have you on.
No worries.
And we'll see.
Very good.
No worries. It's been great. And we'll see everyone else next time. Thank you.
Thank you all. Thank you, Josh.
No worries.